Once you know what you're going to collect against, you need to choose the way you're going to collect. And the primary tools that you're going to have are the writ of execution or the abstract of judgment. The writ of execution is the most versatile. The abstract of judgment is going to be used to create liens against real property. So let's start with the writ of execution. It's going to be used for bank levies, wage garnishments, till taps, and other enforcement techniques. Anywhere where you're having the sheriff enforce the judgment for you. The form itself is fairly straightforward, EJ 130, and caption is just what you'd expect. You have to identify who you are in the case. You also would identify the plaintiff, the defendant. You'd indicate that it's a writ of execution. And something new this last year, up until fairly recently, this box over on the right-hand side didn't exist. And then they changed the requirements that you had to indicate on your writ of execution what type of case it was. Was it a limited civil case, an unlimited civil case, a small claims case, or other? And if you didn't do that, the sheriff wouldn't enforce it for you. They wouldn't even accept it. Well, the forms up until this year hadn't caught up to that. So you were actually handwriting that on the form, and it was just inconvenient. So this will at least remind you to do it, but be sure that you've indicated the type of case, or typically your sheriff is not going to take it at all. Then, right below that, you indicate which sheriff or marshal, what county it's being enforced in. Each writ of execution is good for only one county. You can have as many writs of execution as you are going to be enforcing judgments in for any county. So if the person is maybe has bank accounts in Sacramento County, Placer County, and Yolo County, you might end up issuing 3, 1 to each sheriff. If you're doing that, you always have to be really careful about the possibility and risk of over-collecting, but you can issue as many of them as you want, and the writ of execution is going to be valid for 6 months. Then you indicate the your name, information about the debtor, the date the judgment was entered. If this is a renewed judgment, you would enter the date that the judgment was renewed, and then you would indicate the information on the judgment, the total judgment amount, the costs that were previously on that document you filled out, the memorandum of costs, not the interest, but the costs. If it's under $100, you can file the memorandum of costs in this writ of execution at the same time and claim the $100. You would subtotal that out, the credits that were previously provided, your interest on the judgment, and the fee for issuing the writ is $25. And you're going to include that $25 even if you have a fee waiver. The sheriff isn't going to allow you to, the court will probably not issue if you leave that line blank, and the sheriff may not enforce. So always be sure to list the cost of the writ, which is $25 currently. And then the daily interest. Remember I told you that you figure out the interest by taking 10% of the judgment, divide it by 365, and then multiplying it by the number of days? Well, if you just do the 10% divided by 365, that gives you your daily interest, and you round it to the nearest cent and include it in line 19A. And when the sheriff goes to enforce your judgment, that amount is going to add every day to the judgment, or the amount that they're collecting. Then leave the signature line blank, because that's where the clerk is going to sign to issue it. Yes?
For the writ execution, because you said 6 months, the 6 month date of the judgment is 6 days.
6 months from the date the writ is issued, after which you can then have another writ issued.
So it's not 6 months after the judgment date?
No. 6 months after the writ itself is valid for 6 months from the date it's issued, and when it expires, you can just have another one issued. That means any time in those 6 months, you can then take it out to the sheriff to start, collecting against them. Now, if you're doing something like a wage garnishment, they could start the wage garnishment, but the wage garnishment is going to then just keep going. It's not going to expire at the end of the 6 months, because the sheriff, it's just a time frame for them to start. But if they change employers at that point, you need to get another wage garnishment from their new employer, then you would need to get another writ. And fee for that is $25. unless, of course, you filed it at the same time that you did your application for order of examination, in which case, free.
You still put the $25 in that?
Yes.
Okay, you still do it. Okay.
You still do it because that's still the fee for issuance. It's just thrown in there. You know, so how they do it in their accounting, I have no idea. All right, so let's say that you've got your writ of execution and you want to do a wage garnishment. Truthfully, if you are going to, if your judgment debtor works, this is the most likely, you know, unless they're independently wealthy, have a lot of assets or things like this is the most likely way you will ever be able to collect on your judgment. Because people, they can't, you know, they can't stash, you know, unlike bank accounts where they might stash their money away in their mattress, move bank accounts frequently. Most people need to work to live, and they will keep a job and not change it just because they owe you money. So you obtain your writ of execution through the court, and you need to complete an application for earnings withholding order, form WG001. Caption on this is going to be just what you would expect, except for the levying officer. That's going to be the sheriff in the county that you got your writ of execution for. If it's in Sacramento County, it's going to be the Sacramento County Sheriff's Department, Civil Division, at 3341 Power Inn Road, room 313. Some of you may recognize this as the Family Law Courthouse. It's on the 3rd floor, and this department, this room, is the only reason you ever want to be on that 3rd floor, just so you know. You know, it's going to be on that 3rd floor, and we've got their information up there. Their phone number is 875-2665. The levying officer's file number, you're not going to actually receive that until you actually go up to the sheriff and you fill out their paperwork, and they will give you that number, and you're going to either write, and you'll be able to write it down there. You indicate the sheriff, you know, the county, so Sacramento, your name, the name of the employer that you are seeking to collect, you know, from, and the name of the employer, I mean the employee. So you've got your judgment debtor on the right and their employer on the left. Now, they used to have a spot on this form to write down the last 4 digits of the person's social security number, but since, you know, there's heightened concerns about identity theft and things like that, because this document will eventually be returned to and filed with the court by the sheriff, it'll be returned potentially. They have a form now, WG35, that if you know the person's social security number, you're going to fill it out on that form. Otherwise, you just indicate that it's unknown. You enter the date that the judgment, you know, the amount the date of the judgment, and then A or B, you're typically going to be checking A, indicating you have not previously had a wage garnishment order. B is if you previously had a wage garnishment order and for some reason or the other you stopped it, or it was ordered stopped or something like that. And then there's a spot for you to sign, and then a verification at the bottom where you declare under penalty of perjury everything is in there is true. Now, the way that the sheriff is going to enforce this is they will prepare an earning withholding order based upon the information that you have provided, and you need to use the sheriff's department in the county where the employer is, or they're doing, or the branch that's doing their payroll. And they will actually take this, prepare the wage assignment order, and they will mail it out to the employer. The employer will then complete an employer's return and also forward notice to the employee that their wages are going to be garnished. At that point that the employee receives notice that this is going to happen before all this begins, the employee can file a claim of exemption with the sheriff's department, and the sheriff's department will then forward it to you, at which point you would have 10 days to respond. Now, assuming the employee does nothing, they're entitled to 75% of their wages after mandatory deductions, after taxes and such, and you could collect up to 25%, depending on how much they're earning. But, you know, for most employees, 25%. The basis for the claim of exemption is typically going to be that the additional amounts are needed for the basic necessities of life. and the employee will fill out a financial statement that they will return with their, with their claim of exemption. Now, the secret to overcoming these is to go over that financial statement with a fine-tooth comb, because they're going to claim that, that they can't possibly pay you because all of their other stuff is so expensive that they don't have any money left over. That may be true. If you look at it and the person is barely scraping by and they don't have anything, you can fight it, but it's probably not a whole lot of point to it. But on the other hand, if you look through there and there's a big healthy chunk of their money going to entertainment every month, or they're paying off all of their other non-judgment creditors, those are things that are really easy to attack, because really, the person doesn't need to spend on entertainment as long as your judgment is outstanding. Likewise, if they're paying non-judgment creditors that aren't for the basic necessities of life, so if they're paying off their other charge cards and things like that, well, you as a judgment creditor are entitled to preference before them. So that's going to be one of your good grounds for opposing their claim of exemption. That you are entitled to preference and should be paid first. Well, if you do that, then you would file a notice that you are opposing their claim of exemption. There's a judicial council form, and you would need to serve that on the sheriff, serve that on the employee, whose address you have from their claim of exemption, and also file it with the court. Now, the notice deadlines on this are extremely tight, and rather than completely botch them, I'm just going to tell you, I helped write a step-by-step guide that the library has, that the reference librarian can give you downstairs, or you can download off the library's website, that has all the details as far as choosing your date, because there's a very small range of windows when you set your date and serve it that you will actually be able to have it heard. Otherwise, if you file and request it too late, court's going to reject it. Do it too early, court's going to reject it. And in your worst case scenarios where there are a lot of holidays, I found a few instances on the calendar where you've got maybe 1 or 2 days that your actual exemption can be heard. So I don't trust myself to just speak to you right now and give you the exact deadlines. So now, I told you about Form WG35. If you know their Social Security number when you submit this, it's really easy. Caption is just what you'd expect. Levying officer file number you get from the sheriff when you file it. And there's just a spot to write the name of the debtor and their Social Security number. That's it. And that's all submitted to the sheriff. Information for the sheriff, once again, 3341 Power Inn Road, room 313. Sacramento, California, 95626, 916-875-2665. For whatever sheriff that you're looking for in other counties, most of them have a pretty good page online telling you which is the branch that will enforce it. Some smaller counties only have one branch, but for example, especially larger counties like Los Angeles, they may have multiple branches, and they have a lot of procedures that you may need to go through on their website to figure out who to get it to. But it is there. I've looked it up a few times. And the total cost, $30, which given that this is the most likely one that's going to actually get you anything, is pretty efficient and pretty cheap. So the other way that I see where people are likely to possibly get something, although the success rate is much lower, is the Mank levy. It starts out with the writ of execution to the sheriff, just the same way. And instead of having a judicial council form, each sheriff sets their own procedure slightly for doing this. In Sacramento, you need to fill out sheriff's instructions, and they've got a form online to do it. And the form looks like this. Unfortunately, the one they provide isn't a fillable form, so you're going to either need to convert this information into something you can type in if you're going to do it again and again, or alternatively, you could just handwrite or hand type onto this form. But the levy number, you'll get it when you actually submit it to the sheriff, and then you just indicate the date, the plaintiff, the defendant, the debtor's last known address, case number, if there are any assignees, the date of the judgment, and then you need to provide who it's being served on. That's the bank. Generally, if it's a small bank with only a few branches, you're going to actually need to indicate what branch the account is at and have it served to that branch. Large banks, it can typically go on any of them. But then, when you say levy on, that's going to be the description of the property that you're asking them to levy. Typically, you're going to want any and all deposit accounts bearing the name of the judgment debtor, and then usually with the last 4 digits of their social security number or something like that, if you have it. And you don't need to know the bank account number. You just need, it'll hit any account with their name. Other things that they might have is they might have other types of accounts other than deposit accounts, and you could hit those as well if you describe them in your levy on. And another thing that you can possibly go after is safe deposit boxes. Now, I'm not a big fan, truthfully, of hitting safe deposit boxes, because if you nail one, the cost, the cost to do that is more expensive, and it really is, a Vegas-style gamble. But yes.
I have a question on the IRAs, because that's like a retirement account. You actually can go after their IRA?
You generally are not going to be able to hit certain accounts because they're going to be naturally exempt. I'd have to look at the exact limitations of what would happen, but it's typically going to be deposit accounts.
Okay.
But because they could claim certain exemptions, usually getting around the exemptions is going to be a pain. But in some cases, I believe so. But I'd have to, this is one of those things that I'd have to actually look at, keeping in mind that most of the people I've dealt with don't really have them. So, and usually if you have somebody who has assets, unless you've got a large judgment, those are the people who you're able to more likely get to voluntarily pay you, just to avoid the hassle of going through all of this. By the time you're levying bank accounts, you're dealing with somebody who is either either really, really stubborn and won't come to any arrangement or payment, or somebody who doesn't usually necessarily have a whole lot else. Anyway, but safe deposit boxes are one of the things that I tend to be a little ambivalent about. And then where it says to be served by, typically it's going to just be the sheriff. And the reason why is that they will go ahead and serve it on the bank. They'll mail it out to the bank for their standard fee. There used to be an incentive to use your own process server to get the levy order from the sheriff and then use your own process server, and that was to time the date of the levy. Now, the reason is because back before there was more banking security, you could just call up a bank and say, hey, I just wanted to know if, a check were written by this person on their account, in this amount, would it clear? And they'll say, yeah, that check for $5,000 would clear, in which case you'd know there was money in the bank account to hit. They won't tell you this anymore. And because of that, the incentive of timing, of being able to control the precise moment it hits the bank is more or less lost. Couple of a couple of reasons why you might want to do specialized timing. If your judgment debtor is a business that employs people, one of the best ways to time the bank levy is going to be the night before payroll hits. So if you know when they pay their employees the day before, you hit them with the bank levy, and you've got the highest chance of there being money in the account, because at that point, it's just all been transferred in there. And if you're around afterwards, I'll probably share my favorite story of this. It's kind of evil, so I'm not going to do it right now. Now, but other than that, you would just use the sheriff. Spot for you to sign, you'd submit it to the sheriff, it's $35. Unless you hit that safe deposit box, in which case it's going to be $125 to get the contents of the safe deposit box, plus whatever it costs to have a locksmith drill the box if that's necessary. So it can be kind of expensive. And the reason why I don't tend to go after these safe deposit boxes, or like going after them, is because once you get the contents, most people in these safe deposit boxes have things like their passport other documents that have absolutely no value to you as a creditor. Or they may have things that there are going to be a certain amount of exemption in, like their wedding rings, other private, small amounts of private jewelry, things like that, that even if you could get it, what are you going to necessarily do with it? And they're going to do a claim of exemption anyway, and you're out $125 plus whatever it costs to drill the box. Nonetheless, if you think that these people that you're collecting against possibly are sitting around with large wads of cash in a safe deposit box, oh, by all means hit it.